start recording, and you can start speaking. I will, sitting, I will, no, I will be on the timer down there, and if you need the light up for the audience to see it, you just point it to me, or just say, I will be presenting right now, and I will try to get it, okay?
We'll start now. Yeah. It's stereo. All right. I think we're ready to get started. Welcome to this workshop number 87 on law enforcement, cyberspace, and jurisdiction. My name is Christian Borgreen. I will be a moderator. Obviously, I'm normally with the Computer and Communications Industry Association in Brussels, and I'm delighted to be co-hosting this session with Alexander Seeger and the Council of Europe. The theme of law enforcement access to cloud data is fairly known, including at the IGF, so we're not going to spend too much time introducing it, but I'll just, for those who are brand new to this issue, just give a little taste of it, and then hopefully we can go a little bit deeper and look a little bit towards some of the solutions that could be addressed. At its basic, cyberspace challenges the notion of territoriality and jurisdiction, and especially when it is especially challenging for law enforcement to access data and evidence which is stored in the cloud. Just a basic example, you can imagine a criminal suspect in country A trying to get evidence that is stored in country B, stored in the cloud, but it actually is stored in country B from a company which is legally established in country C. That is just the basic. There's many, many more facets and challenges beyond that. But obviously this lack of legal clarity that cyberspace has brought upon this discussion is a problem not only for law enforcement but also for users, for companies, for our rights, and for companies there is of course the risk that they might, when they're trying to address one country's rules, that they might be in conflict with another country's rules. And where in the few instances where there are legal agreements, for instance, mutual legal assistance treaties, MLATs, these are also often very cumbersome and take a very long time for law enforcement to use. All right, no more introduction here. This session will quickly explore some of the main challenges identified by the main stakeholders, which we are trying to invite on this panel here. We will look to some of the national, regional, and global solutions for cooperation. And of course, we'll also be discussing a little bit how we avoid fragmentations of cyberspace, reduce conflict of law, and ensure that rights are adequately addressed for individuals. The format will be very short interventions, 4 minutes maximum from each speaker here, followed by Q&A by the audience. And please, if you are remotely participating, thank you so much for doing so. You can also be sending your short questions via Twitter using the hashtag WS87, Workshop 87. With no further ado, if we can get the slides up here. If we can jump to the next one. So what we try to do here, instead of spending, not yet. Just one second, okay. There's already law enforcement here, it's to have sort of 4 of the generally shared goals for this discussion for law enforcement access to data, just to have sort of a general framework. And what we'll try and do is to use these 4 general goals to have these guide our discussion, which hopefully will be more of a solutions-focused discussion. So not only talk about all the problems, how complicated they are, but actually we'll hopefully be trying to have some solutions that can be addressed further after 1 hour of panel discussion. All right. Now we'll jump to our first speaker. I spoke way too much. I hope you can keep it within 4 minutes. Our first speaker is from Brazil. It's Naide de Oliveira, Federal Circuit Prosecutor of Rio de Janeiro, but also coordinator of the National Cybercrime Working Group in Brazil. And I was hoping maybe you briefly can just talk a little bit about sort of the main objectives, obviously for law enforcement, some of the concrete challenges that you are facing, you and your colleagues are facing, and some of the more maybe alternative measures that Brazil's government has taken to make sure that you get this access, for instance, through data localization. Please. And I think we'll jump to the next slide.
Good afternoon for all. I would like to say I am very honored to be here, and thank you, Mr. Alexander Sergei, Mr. Christian Bourguin, and Monsieur Bertrand de la Chapelle for inviting Brazil's Federal Prosecutor Office to attend this meeting, giving us the opportunity to present our view on the jurisdiction issue concerning Internet. As Christian said, I'm a Federal Circuit Prosecutor in Rio de Janeiro, Brazil, where I coordinate the National Cybercrime Working Group and represent here the International Cooperation Secretary of Federal Prosecution Office. We have two levels of jurisdiction in Brazil, the state and the federal one, and we have a common discussion group for cybercrimes issues in the country. Brazil's approach to the theme of Internet jurisdiction was settled with the passing of Marco Civil da Internet, our civil rights framework for Internet. It was passed after an extended and comprehensive public consultation process, and despite being a civil rights framework, it regulates data preservation concerning connections to Internet and access to Internet applications, and it also determines the legal procedure to law enforcement authorities or a private person in civil cases to obtain data targeting a judicial case. Although our Marco Civil is not yet a data protection law, it is already under discussion at our Congress right now. It does guarantee essential rights on Internet, such as privacy and freedom of expression. Concerning jurisdiction, our civil rights framework is very clear when it states that any collection, storage, or processing of data or communications performed in Brazil by a server provider constituted under Brazilian laws with an office established in Brazil must follow Brazilian legislation and obey judiciary orders. The Article 11 grants that even one of these conducts performed in Brazilian territory is enough to bind the company to Brazilian legislation where there is a branch in Brazilian territory or it is part of the same economic group. That means when at least one of the company is established in Brazil. Even if the company does not have an office in Brazil, it is bound to Brazilian legislation when the service is offered to the Brazilian public. That means to us that any Internet company or operation, its service in the country is under Brazilian jurisdiction and must present in court all personal data under a Brazilian lawful warrant, such as subscriber information, traffic data, and content. Since legal requirements are met, what is revealed by the competent judge. We do need an improvement on IMLETs to deal with the companies that are not established in the country, only offering its service, but for those that are well established, even paying tax in the country, our law is very clear and the judges are enforcing it by legal means. From our point of view, there should be a common framework among countries so that the companies wouldn't have to comply so many different legislations. But for now, it is a matter of which company controls data and if this company is established in the country. For example, Brazil, this country has jurisdiction over the company. The organized crime is mile ahead of us, and the cooperation among the states very much welcome. I congratulate again the organization members for this great initiative. That's all.
So understand you correctly, for law enforcement, the most important is that you get access to data, you protect, of course, the privacy. You feel that you feel more confident in getting that data when you're sort of forcing through law data operators to store the data locally in Brazil. But so you're sort of having a two-track approach where you forcing data to be stored locally in Brazil, but at the same time trying maybe to have a common international framework for MLATs, for instance?
For us, we will welcome the initiative regarding the establish a common patronization to requests, metadados in criminal procedures, in order to have more efficiency and more accurate responsible by internet service providers. And it's not necessary to have a data center in our country. Of course, it's not necessary. But if the provider has an office in our country or offers their service for Brazilian users, it's enough for us to these providers have to obey our legislations.
All right, thank you so much. I think we'll have a lot of questions to you as well. I think we'll jump directly to our next speaker from Microsoft, Paul Mitchell. What do you make of all this here? Should we just...
I'll just tell you a couple of stories to sort of set the tone.
Please.
So many of you know that Microsoft's been involved in a legal case with the United States government that relates to email data that is stored in one of our data centers in Ireland. So our initial filing in that case began like this. Imagine this scenario. Officers of the local Stadtpolizei investigating a suspected leak to the press descend on Deutsche Bank headquarters in Frankfurt, Germany. They serve a warrant to seize a bundle of private letters that a New York Times reporter is storing in a safe deposit box at a Deutsche Bank USA branch in Manhattan. The bank complies by ordering the New York branch manager to open the reporter's box with a master key, rummage through it, and fax the private letters to the Staatspolizei. So it goes on to imagine the reaction of the US Secretary of State, since this action would bypass all of the existing legal formal procedures between the United States and EU countries, and the claim that it was nothing more than a German company producing its own business records. So you can all imagine in your own minds what the cases, the points of the case are. I'll just make the observation that it's not actually about the content of the emails in question at all in this case. In reality, it's about principles, the rule of law, the balance of security and privacy, and the interplay between national and international law. Now, this case is not over yet. We won the last appeal round, but the United States has indicated they would like to take it further. So next, we have an example of the horrific Charlie Hebdo tragedy in Paris that happened last year. And while there was a gigantic manhunt going on in Paris, at 5:42 in the morning, we got a call from the FBI telling us 2 terrorists in Paris had Microsoft email accounts. They served us a lawful order that we reviewed, and we pulled the email, and we had it to the FBI for delivery to the French authorities in 45 minutes. The key point here is that there are, in fact, today, frameworks for international agreement that can and do work. So in the third example, the Brazilian police arrived at the apartment of one of our executives in Brazil a while ago. They burst past the gates. They didn't just knock on the door. They were a little more aggressive, and they demanded that he be produced and that he appear before a court, because the Brazilian police were demanding, as part of a law enforcement investigation, that Microsoft turn over Skype data for a Brazilian customer. The problem was that the data, in this case, was not in Brazil, but in the United States, and it would be unlawful under US law for us to provide it. As it also happens, he was in the US at the time, so his wife was not very happy about the event. The key point there is that when dealing with data requests, complying with one country's law may result in breaking another country's. So these stories are real, and they illustrate the point that the legal frameworks actually need to evolve to keep pace with the technology's evolution. The existing laws we have don't sufficiently address the increased complexity of the internet and cloud services. But it's also acknowledged that the growth of the digital economy, the future of the Internet of Things, and potential innovations around big data, machine learning, artificial intelligence, all of these things that have potential economic and social benefits, they all actually rely on the ability to transit data back and forth across borders for providers to balance the load on their cloud service systems and on the networks, etc. And all countries want to realize these benefits. So somehow, they all have to cooperate to solve the problem. So I'll just close by noting that Microsoft is perhaps one of only a few at the scale where this is such a big problem. We operate in 122 countries. We have well over 1 billion customers. Some of those customers are governments, and we have hundreds of data centers located all around the world, which are intentionally designed to be able to do geo-balancing and offloading and redundancy to protect the data. But for us to actually offer the services that we do, we need our customers to be able to trust us, and for them to trust us, we have to have a framework of trust that is grounded in the rule of law with due process that applies globally. I'll stop there.
Can I ask you very briefly? You're obviously an international representative of international company, very active in this discussion here, maybe the leading company most active in this discussion. Where should we look towards good sort of solutions? We don't have enough time to go into, but can you just point a little bit and we can discuss further after?
Well, so I'll give you an example of some things that are sort of in process and working. The Internet and Jurisdiction project, which I'm sure Bertrand is going to talk more in detail about, has done a great job of actually capturing both cases and then some ideas of best practice. A couple of things that are pushing the boundaries in the right direction are work that's being done on transparency and on the ability for companies like Microsoft to be transparent about when we get data requests, what kind of data requests they are, and what we're doing about it. So we and the other large providers are all doing transparency reports at some level. The Ranking Digital Rights Project Rebecca McKinnon runs is an example of, again, trying to point in a particular direction that is actionable. And so those are things that are in process. There's also the U.S.-UK cooperation agreement, which is a starting point that might be scalable to other sort of new forms of multilateral agreements for this.
Very good. Thank you so much. We're going to jump to our next speaker, academic Natalia Fodic from the American University. I was hoping maybe you can talk a little bit about and you're also from Brazil, so maybe we can get a little bit more insights, maybe academic point of view on some of the things we heard from Brazilian law enforcement, but maybe you can give a little bit thoughts of what we need to talk about when we talk about territoriality and jurisdiction.
Thank you so much, Christian, for the invitation. I'm really honored to be here today. First, I wanted to raise the question on the reasons why it's so crucial to discuss these issues. Well, besides any social and human rights issues involved in all these processes and due process, there is a huge economic impact in not having a proper system in place or having a flawed system or having a system that needs improvement. A recent study that was undertaken by Brookings Institution in Washington, D.C. found that last year only over $1 billion was the economic cost of app shutdowns at the national level in different countries. And that's not, I'm not even only talking about the shutdown of the whole internet, but the only specific apps, like, it happened several times in Brazil last year and this year. Besides that, the online services are setting the rules of the game anyway. So the Center for Technology and Society inside the FGV in Brazil has recently also launched study in which they analyze several online platforms, and 86% of these platforms are only telling which specific jurisdictions they wanted the disputes to be. So, they're setting the game, so we rather have, a good system in place. So overall, in terms of mutual legal system treaties, they can delay a lot the process. So I guess that's one of the main reasons why we should also talk about how to improve the system. On average, 10 months in Europe, I have, it takes to have a reply. And also, we have to talk about the alternative options to mutual legal system agreements. Do we really want to have direct private requests? Do we want to have, like, considering that the internet is already so much privatized, do you want to foster the privatization of governance even more, or do you want governments also, to be involved in having like a proper transfer of data and in which rights and due process is guaranteed? Moreover, it's important to understand that in many cases, if we don't have a proper system in place, this might lead to data localization mandates and also government hacking, which can also have even worse consequences in terms of human rights. And actually, I would tell everybody to take a look at a paper that was recently launched by Access on government hacking. And, it will be interesting also to understand to what extent not having a system that needs to be improved is leading to data localization mandates. So, we had the recent case of Skype in Belgium, WhatsApp in Brazil. Basically, they're saying that having encrypted messages is pretty much, not being able to intercept the communication is illegal. So I'm not sure that's the way we want to, go and develop. In Brazil, just to finish, right, because my time is almost over, to what extent having this takedown is necessary and proportionate? 100 million users were affected by taking down WhatsApp in Brazil. So is that what we really want? In the end, they also migrated to Telegram, so that's not that bad. You create competition too. But, these are my brief points. Thank you.
Great, thank you so much. And I think the point on human rights, freedom of expression, when authorities, and I'm sorry for bashing a little bit here, but when authorities just, if they have sort of beef with one provider, that they just shut down the whole app, and then how many thousands?
100 million users.
100 million users suddenly couldn't use one popular app in Brazil. That is also one way to go about it, but probably not the best way in the future that we want to go about it. Okay. Speaking of freedom of expression and human rights, Eva Lanzo, you're director of the Free Expression Project at the Center of Democracy and Technology. Could you maybe expand a little bit, and hopefully we can start, because I sort of promised the audience to talk a little bit about the solutions. So if we can start talking a little bit more solutions and not just the problems.
Great, thank you so much, and good afternoon, everyone. So my name is Emma Alonso. I'm at the Center for Democracy and Technology, which is a digital rights advocacy organization based in Washington, D.C. And at CDT, my colleagues and I have been working very closely on this issue of transborder access to data. And I wanted to actually take some time to talk about the transparency aspect of this. I think in four kind of unifying goals that we had, goal 3 was really to provide transparency and clarity for users, governments, and companies in how these transborder access issues and scenarios are kind of playing out. And so one area where we've been doing a lot of work on this topic is in the Freedom Online Coalition's working group on privacy and transparency. The Freedom Online Coalition is a coalition of 30-some governments from around the world who work together to promote an internet freedom agenda, and they have multi-stakeholder working groups that work on a variety of different key substantive topics that we're facing on the global internet. In November 2015, our working group on privacy and transparency put out a report on a number of consultations that we'd done with governments and companies describing sort of the state of play and around transparency regarding government requests to companies for user data or content restriction, and trying to identify some of the obstacles and opportunities for transparency, because it's very clear that there's a growing demand for more information from governments and companies in this issue around the world. And I think it's really important as we kind of talk about potential solutions here to really understand sort of what is the case for transparency, what is the point of it. And it's not really just transparency for transparency's sake. It's not that we want to see, lots and lots of grids of numbers and stacks of reports because that in itself is a good. Transparency really enables a couple of key elements. Of course, it enables transparency. It is transparency, enables transparency. And that chain leads to enabling accountability. We are all more empowered to exercise oversight over our governments and the companies that we choose to do business with if we actually have an idea of what they're doing and what's going on. It promotes individual empowerment. It gives citizens and individuals an understanding of how companies and government action affects them individually and directly, and also affects how these entities are shaping society and affecting the information we have access to and what our governments know about us. This kind of empowerment can also lessen the chilling effect that we know surveillance exercises over individuals about their willingness to express their views and use information and communication technologies. And then, of course, transparency helps to inform policy discussions and advocacy and helps us find the kind of solutions that I think we're all really here for today. So I think one of the, there's a couple of ideas that I wanted to just sort of throw out there for discussion. In terms of how we develop laws, policies, and frameworks with meaningful transparency in mind, I think one key effort or one key aspect to keep in mind is that at an operational level, providing transparency can actually be somewhat challenging for companies or governments. It can be a big data management project. You run into all sorts of questions about what data should and shouldn't be provided based on national security concerns or other kinds of issues. And so anytime we're talking about how to provide, did we lose the mic? No, okay. Anytime we're talking about how to provide transparency in kind of proposals for reformed frameworks, we really need to keep that in mind as a fundamental goal as we're defining what those projects might kind of pursue. And I see I'm out of time, and maybe that's why my mic has changed, so.
We're not shutting you down when you, well, although that is very good for a moderator in the future just to shut people down. So maybe we'll consider that in the future, maybe not on a freedom of expression related panel. No panel will be complete when we talk about law enforcement and the internet without having Bertrand de la Chapelle. I'm not even going to introduce you. I'm just going to jump directly. And I will shut you off if you do not come and help us get a little bit closer to what we're trying to achieve here, which is sort of pointing to some solutions. Thank you. Thank you very much. Oh, you have to turn.
Thank you. Thank you, Christian. So I'm Bertrand Lachapelle. I'm the Executive Director of Internet and Jurisdiction, which is a policy network that deals with jurisdictional challenges on the Internet. We have 3 programs, and one of them is specifically dedicated to this issue of cross-border access to user data. I insist on the term cross-border. The fundamental problem that we're confronted with is the fact that this information is stored by companies that are very often in a country that is different to the one where the crime that is investigated is taking place. And in addition, those companies are serving users around the world without, as was said before by Nede, without having any local offices or any local activities. And by definition, any service on the internet, hopefully and fundamentally positively, is accessible everywhere in the world. So this raises a big challenge. And in the context of the Internet and Jurisdiction Policy Network, we held in November, 2 weeks ago, a conference in Paris called the Global Internet and Jurisdiction Conference that had one of its tracks dedicated to this. And what I would like to do here is, on the basis of those elements that are on the slide, to look very quickly at a few of the elements. The first element is that it is very important to frame the problem appropriately and to recognize that this is a problem that is a problem for all the different actors. There are no good and bad actors, the ones that are protecting and the ones that are infringing. There is a common public interest need to be able to find the information when there is a criminal investigation. The problem is that the current mechanisms of mutual legal assistance treaty lead to a situation where it is either cumbersome, and in some other cases, as Paul has mentioned, it leads to a conflict of law and puts the companies in a situation where they have to choose which country law they violate. If they abide by one country, they actually have to violate another one, the laws of another one. And so fundamentally, the key common challenge is what are the proper frameworks, what are the proper standards for due process to govern those cross-border requests that are coming from a public authority in one country to a private actor in another one. So beyond the framing, what is important to know is that this is a problem that is being tackled by several different initiatives. There are initiatives in the US, some of which have been mentioned, and Hema has mentioned in particular a process whereby a certain number of civil society actors and companies and academics, with the participation actually of the US government, is looking at ways to handle the specific situations when the only nexus of connection with the US is the use of a US-based platform. The crime is in one country, the investigation is done in one country, but the data is held by a company that is based in the US, and that's the only nexus of connection. So how to develop safeguards and procedures for this is one of the things that the so-called Daskalwood's proposal is exploring. At the same time, the Justice Department in the US is exploring a potential bilateral agreement with the United Kingdom that could be scalable afterwards to handle those specific cases. But in parallel, in Europe, the Council of Europe, and Alexander Seger in particular, is dealing in the context of the Cybercrime Convention on how to improve those mechanisms. And the European Commission has been tasked by the Council of the Ministers of Justice and Home Affairs of the European Union in June with a specific role to develop standards and processes for access to basic subscriber information. It's very important that all these different initiatives are aware of what is being discussed so that there is a chance of policy coherence, and this is one of the things that we helped facilitate in Paris 2 weeks ago. Now, quickly towards the solutions, what is important when we try to address those issues is to deconstruct the big problem into what we label as manageable chunks. So to give you examples, one first element is the operational challenges in trying to find a solution, and I'll list just a few of them here. The diversity of data types. The rules are not the same for basic subscriber information, for traffic data, and for the content of emails, for instance. I won't get into details because of time, but it is important to know that the rules currently are very different for those three types of data. There's a very important question of how do you validate the authority and the authentication of the requester? How do you know that a request that comes from a Yahoo Mail account is actually a law enforcement agency in Kenya or in France? There is a question regarding the criteria for jurisdiction, and Paul was mentioning the Microsoft case, which is a very important case trying to distinguish whether the location of the company or the location of the server is actually the relevant criteria for establishing jurisdiction. And to be honest, it is very likely that neither is a good criteria, because if you apply them too rigidly, it actually leads to certain incoherences and bad solutions. So one of the challenges that is being discussed at the moment is, are there other criteria for determining jurisdiction, including the location of the crime and or the nationality or the residence of the person whose data is being requested. And so just to finish, beyond the challenges that are common, it is important to identify what are the common cooperation areas that can be explored. And in that regard, the criteria under which there is a notification of the user is a very difficult issue. The criteria for determining jurisdiction, as I said. And finally, everything that is related to transparency and due process mechanisms.
Thank you. I think we're getting closer to some solutions here. I mean, you're clever, Bertrand. You sort of waited the 4 minutes, and then you got to your pointing to the right solution. So you got a little bit more time there. But that's okay, because you're helping here. We got a little bit closer to some solutions. We're gonna go, before we go to our last speaker, I would just encourage you to send your questions on Twitter using the hashtag WS87, Workshop 87. and also have your questions ready here in audience, because in 4 minutes we will already go to Q&A, and then you can ask our experts all your questions and comment your comments as well. And of course, our final speaker, Alexander Sieger, is head of the Cybercrime Division of the Council of Europe.
Thank you. And I also had one slide, if you could put it there.
Yep.
This is a real technical challenge. We agreed we have each of us only one slide. Okay. What I'm going to talk about in the next 4 minutes is the type of solutions that are currently under discussion within the framework of the Budapest Convention on Cybercrime. And I would like to underline crime because we talk about a criminal justice context. You know, a number of things you talked about referring to national security arena. We talk about criminal justice here. Specific investigations, specified data needed. The Budapest Convention has currently 50 parties, another 17 observer states. Mexico is an observer state. Brazil is not a party, not an observer state, but I think Naida and Priscilla will work on that. The United States is a party to it, Canada is a party to it, European countries, Japan, and many others. The parties to this treaty meet twice a year as the Cybercrime Convention Committee, and the Cybercrime Convention Committee established, it's all on that slide, the Cybercrime Convention Committee established 2 years ago a cloud evidence working group to identify solutions on how to address the issue of criminal justice access to evidence in the cloud. The group produced the final report about 6-8 weeks ago, and that was then discussed 3 weeks ago by the Cybercrime Convention Committee, and I'm coming to this now. The rationale is that we are talking about cybercrime, yes, but also about electronic evidence in relation to any crime. That changes the scope and the scale enormously. Evidence is on servers, often in foreign, multiple, shifting or unknown jurisdictions. And without data, there is no evidence, there is no justice. And I fully share the frustrations that Naida and other prosecutors have, because we have in the Cybercrime Committee about 120 prosecutor and law enforcement officers that say we cannot protect society against crime anymore. Less than 1% of any crime, of any cybercrime reported actually ends in court proceedings. And only a very small part is actually reported. You have to keep that in mind. So a number of very specific issues have been identified by the Cloud Evidence Group. An important one is we need to differentiate the type of data needed. Law enforcement most often needs subscriber information. Traffic data, content data comes later. But without subscriber information, you cannot even get started, cannot even motivate a mutual legal assistance request. The group identified the limited effectiveness of mutual legal assistance. I don't think we have to go more into that. We have the issue of loss of location or loss of knowledge of location. We don't know where the data is. And that leads to a jungle of unilateral solutions. And I would say that the Brazilian solution is part of this jungle now. That in frustration, because governments and law enforcement have a job to do, they find their own national solutions to address the problem, and that creates a jungle that we have now. Then we have the issue of when is a provider that may hold data actually in my territory? From what moment onwards are they here? Are they here when they pay taxes? Are they here when their service is accessible? And that sort of things we need to define, and that was also mentioned in the presentation by the Brazilian prosecutor earlier on. We have this generosity by US service providers that they, under US law, can provide voluntarily subscriber information. Content is another debate, but provide subscriber information they can provide. There are a number, but voluntarily, there are a number of rule and law challenges and data protection challenges that come with it in that connection. By the way, parties to the Budapest Convention, other than the United States, in 2015 sent 138,000 requests directly to Apple, Google, Microsoft, Yahoo, Twitter. I think there was another one, to 6 providers, 138,000 requests. It's about 10 times more than mutual legal assistance requests were sent, just to 6 providers. We have the issue of emergency procedures. Paul from Microsoft mentioned the emergency procedure used in the mutual legal assistance request in the case of the Charlie Hebdo attack, which worked extremely well. US service providers can again cooperate sometimes on content in emergency situations, child abuse, terrorism, and so on. They can do that. Non-US providers are not allowed to do that. So we have also an unequal playing field here, which we have to underline. And then there are the data protection issues, where again, for European countries, for European Union countries, and for providers offering a service in Europe, there will be a different situation from April 2018 onwards, when the new European Union data protection rules enter into force. So 5 solutions identified, not going into detail. There's the website indicated here. You can find the report in detail. One is we have to make mutual legal assistance more efficient. There is no way around that. We cannot come with more adventurous solutions if we don't make that work, if we don't invest more resources, better skills, streamlining of procedures, and so on when it comes to mutual legal assistance. The second solution, the second part of this package of solutions, is a guidance note on Article 18. Seems now a bit weird what it means. Article 18 Budapest Convention is about production orders, meaning orders to a provider to produce data. And Article 18(1)b talks about ordering a service provider offering a service on the territory to produce subscriber information. Now the debate is, what does it mean, offering a service, and so forth. But if consensus can be found that Article 18(1)b can be a legal basis for a domestic production order to a service provider offering a service on a territory, and the connecting factors have to be fully defined yet, there is debate about that, then that may create a legal basis for this type of requests to providers like Facebook, like Microsoft, and many others to produce data. It may also protect the service providers, by the way, because there is a lawful order at the origin. And then, of course, the third solution is that this whole complex of domestic production orders has to be clearly defined in domestic law. You have a whole variety, even in Europe, among parties to the Budapest Convention. In some countries, a police officer can order the production of data, subscriber information. In others, you need a court order for the same thing. There's no harmonization whatsoever. Finally, the fourth proposal is, and that has been agreed upon, is practical cooperation with providers to improve it, to use online tools, to make it clearer for providers what are the powers of law enforcement in different parties to the Budapest Convention, so that if Microsoft gets a request from a police officer in country A, you may realize a police officer is not authorized to ask this from you. Only a prosecutor can do it. And if you get it from country B, you will realize, based on this tool, only a court can issue an order to produce this data, and so forth. We also, by the way, agreed that the Cybercrime Convention Committee would meet at least once a year with providers to discuss issues and also to listen to your concerns from the provider side. And finally, and this is a longer-term solution, we expect the final decision to be made about starting this in June next year, is a protocol to the Budapest Convention to find internationally legally binding solutions to address a number of issues here. And I think I'll stop here.
Thank you so much. I'm happy. We got a little bit closer to some solutions. You actually have some very good lists here, so thank you for that. Now we're going to open up for Q&A from the audience, and hopefully there'll be a lot of questions. And hopefully there'll be someone with a microphone who will... This microphone? I'll just throw it to people. I can see one. I see a question there, the gentleman with a phone, and then there's one in the very back. Maybe we'll take that one first down there, and then we'll go to you afterwards.
Hi, I'm Leandro from Argentina for the Association for Civil Rights. I'd like to raise a point that I believe is crucial in this debate, that is the expansion of investigative powers of law enforcement, specifically speaking about Rule 41 that has been approved in the US that expands powers for judges to issue warrants on a global basis for remote access to bring away or hacking. And I'd like the input of the panel on this, as I think it's setting a precedent globally to every country basically just allowing judges to issue warrants that are cross borders, and I think that is worrying on a human rights perspective, right? So I'd like the input of the panel on that.
Great, thank you so much. There was a question here, sir.
Mauricio Hernandez from Mexico. So it seems, according to what I have heard, that compliance rules regarding or improved by international corporations could be the best manner or path so to translate those principles into an enforcement law or to binding principles in order to provide certainty about the data transfer or maybe the storage abroad from country A into country B, and then to exercise some prosecutions internationally. Am I correct?
Very good, thank you. I think I understood the question. And a final comment here, and I think we have one question also. Sorry, a question here in front. If we can get the microphone up front here. Okay, we'll take a full throw.
Hi, I'm a Brazilian lawyer, and I want to highlight that the blocking of application in Brazil is due to a different interpretation from that proposed by law, which does not consider the principles laid down by Marco Civil. And what experts in the field are expecting is that the authorities become more open to understand a subject that is new to them. Thank you.
And then I think we have a question up here in front.
Thank you. Thomas Fitschen from the German Federal Foreign Office. I don't have a question, but would like to give an answer, namely to your question about practical measures.
Yes.
Concerning transparency, Germany and Brazil are running the General Assembly resolution on privacy for quite some time. This time, we have introduced paragraphs in the preamble that note or welcome voluntary measures by companies to provide transparency. And then we have two paragraphs in the operative part, namely one calling on states to enable more transparency measures, and another one that addresses companies, also encouraging them to be more proactive about transparency. So that is a practical thing, and now both sides, enterprises and governments, should just simply follow up on this. Thank you.
Very good. And then we had one question which maybe is a little bit more relevant to Paul. It's regarding a prosecutor for instance, in New York. Are they best served to sort of come up with a global framework for how to get sort of global access to data? Maybe you can consider that one. But I mean, this is a new topic. This is a fairly new topic in terms of interpreting. There's no legal framework, and we have judges in New York, maybe in Brazil as well, who are trying to tackle this question here. Maybe we can take that question first. If I don't know if you want to go first, Paul, and then afterwards.
So I'm not entirely sure I understood that question, but I mean, if the question is should some American judge make the decision on worldwide who should have the right to do what, I think the answer is clearly no. I think most of the rest of the world would have a problem with something like that. I think Bertrand had a slide up there that basically categorized the problem. I think you had your 4 buckets of problems, and I think what the warrant case does is it puts all of those problems together in one case in a way that you have to kind of figure out what is the germane issue? Is it where the data is? It's where it's processed. Is it who the data pertains to? What happens if it's data that it's a communication between an American and a German, and it's stored in a Brazilian data center for just some whose law applies? Those are the unanswered questions. So just some of the unanswered questions. I think what we're really trying to advocate for as a whole is that we start on a global basis, or continue actually since the conversations have started, but that we actually work towards clarifying processes that one would go through in the instances where we have these conflicts. And we've talked a little bit about the idea of process standards or process architectures that get to the how you go through the process from when you get a request however it gets to you, to where the decision points might be where you have to arbitrate between, is it Brazilian law or is it US law? And maybe that gets you ultimately to a place where you start on the international cooperation side. You identify how between pairs of countries, and eventually you might get a broader group and a broader convention that would result from that. But what is clear that is not a workable solution is a unilateral decision from a judiciary on any country that my law is the law that matters globally, and you will all fall in line, because it's not practical, it's not implementable in any real way, and the way the internet works today.
Do you want to
try to grab access to, Thank you. I think there's an important element that has to be taken into account here, which is that there's a sort of pendulum swing at the moment. We were in a situation where the frustration that has been mentioned was clearly that there was no possibility of accessing this data. And what is happening at the moment is that there's a pendulum swing in the opposite direction, because in trying to solve this problem, we get into situations where there is an extreme extension of the jurisdiction criteria on any kind of territorial hook, because it's understandable. The simple fact that you're serving, for instance, in the case of Brazil, and in the case of the data protection regulation that is going to be implemented in 2018, the simple fact that a service is accessible in a country is now a hook sufficient to exercise jurisdiction, which is important. The Microsoft case is also touching upon the question of extraterritorial extension of sovereignty, because if the US government prevails in the court decision, it may mean that the US authorities would have the legal capacity to access any type of data stored by an American-based company anywhere in the world. And here, there was a question regarding the challenge of extraterritoriality towards human rights, but I think it's important for everyone to understand that the challenge of extraterritoriality is also a problem for governments themselves, because in as much as everyone is trying to solve its own problem, the fact that another country is going to apply something extraterritorially and limit your own sovereignty is of course a problem. Hence the need for cooperation. And here the question of whether the judiciary is the best placed actor to actually set the norm is clearly a negative answer, because the Microsoft case is what I often qualify as a lose-lose situation. And in many respects, you can see that there are other cases that are related not necessarily exactly to that, but touch upon extraterritoriality. You get a case in France regarding the right to be de-indexed that touches also on the territorial extension of the right to be de-indexed. There's the Equustech case in Canada. There's the Microsoft case. This question of the territorial extension of sovereignty and the jurisdiction criteria is one of the most important one, and there probably is a need to move slightly away from the pure territorial basis. This is something that goes in the discussions in the Cybercrime Convention. It is also being discussed in the approach by the US groups that I was mentioning before. Moving from a pure territorial hook and understanding that the exercise of sovereignty needs to be respectful of the sovereignty of other actors, and that there is a sort of responsible exercise of sovereignty is the way to find the balance. Generally speaking, I think we're in a situation where if we're not careful enough, the jungle of solutions is producing what we have labeled a legal arms race, because every single actor in this prisoner's dilemma situation is trying to find a solution, and the cumulative effect of all the individual decisions is actually not only making the problem harder to solve, but harming every single actor in the long term.
Very good. I think we had a question about Brazil and the interpretation of the Brazilian law, which I know very little about, but thank God there's two Brazilians on this panel here, so maybe we can first turn it to the academia.
Sure.
Because, I mean, how do you implement a law if it's not entirely clear?
Yeah, I love that Bertrand used the expression of prisoner's dilemma, because I think it's a great one. Well, first, I think that your point related to judges is crucial. We need to train, prosecutors, judges in interpreting and understanding the rationale behind the civil rights frameworks in Brazil. Because first of all, this law was intended to guarantee that rights exist before any, before criminalizing the use of the internet. So training judges and, the whole system is crucial for sure. Second, we actually have some pending cases before the Supreme Court in Brazil now to discussing whether takedowns apply, whether using this law that was actually enacted in 2014, if takedowns actually are supported by this law or not. So we have cases even in the Supreme Court right now discussing that. So I think, and Kristen also asked me here, the law is clear. I think in terms of the jurisdiction, it's clear. It's clear that, data doesn't need to be stored in Brazil, but we have jurisdiction over the data, so that's clear in the law. However, what's not clear is whether, these takedowns respect the overall intention of the law and some specific clauses in the law, and whether takedowns are should be the solution or not to cases whether the due process legal system prosecutors are not.
And when the Brazilian government blocked one service, a communication service that 100 million people use, could that be in conflict with other Brazilian laws or principles?
Yeah, sure. So, constitutional rights, and also the Marco Civil, which is the civil rights framework for the internet itself. So there are other parts of the law that talk about how important it is to allow for this freedom of expression.
Thank you. Do you want to comment?
I'd like to say that our framework, civil rights, states very clear that providers have to obey our legislation. It's clear for us. And there is a penalty about suspense the service if the decision is not obeyed. But all the prosecutors, the federal prosecutors in special, we know it's so difficult for the society to understand that, and it's a problem when 100 million of users is out of the service because a decision in one process. And we, last August, we prepared a technical note and shared this document with all the prosecutors in the country. To say to for the state prosecutors that it's not a good penalty for the providers to obligate them to obey the decisions, because you have other penalties that we think it's more efficient, as block the financial block at the account of the provider in Brazil. The federal prosecutors asked the federal judge to block these accounts, and we think that the providers are a capital enterprise, and it's more efficient to obey the decisions when you have a lot of money, millions of reals or dollars blocked. So we think it's better solution than to interrupt the service and prejudice all of the persons in the country.
think there's a follow-up comment from your colleague, I believe, who is sitting here in front, right here.
Good afternoon for all. I'm Priscila Schreiner. I'm a federal prosecutor in Brazil. And I work not just with cyber crimes in Brazil, but I also work with human rights. I'm a federal prosecution from the citizen area too. And as all of you said, mainly Natalia, I'm like not just a prosecutor, but a citizen, very worried about the privacy in the internet and the security in the internet. What we tried to do, and I say we all Brazilians tried to do with this law, I think Nate said there was a huge discussion, open, public, huge discussion for all the multi-stakeholders in Brazil to give their opinion, to give their base, their reasons, to us to get in a law that's the Marco Civil, the Internet Civil point. And what it's important to say here is that this civil mark is not just a right for the prosecutors, the judges, or the authorities to get in and take some information. It's a right for all of us, for the citizen, because it means that no one, even the authorities, and it will be abuses if the authority, the police, the prosecutor, the judge decides against this. Sorry. And no one will be, everyone has the guarantee that you just have the privacy, your privacy damaged by following some rules that's in the law. And about the privacy, I'm finishing. I don't want to take so much time.
You have to bring a chair up here so you can join the panel.
Sorry, Chris. But I would like to say that, like a citizen, our privacy is protected. We have a law. Of course, we must work a lot with the jurisdiction, everything. But we have a law that guarantees that my son that was raped is going to be found by an authority. We have reasons to search. We have just the criminals must be worried with this. So I would like to point this, and really, I'm really finishing, Chris. Just 1 minute, because it was important, I think, for the Brazilian lawyer, Nate said, but I would like to give you an example. All of us know, and we have the car wash Lava Jato operation in Brazil that's all over the world knows, and what's happening. And in the car wash, the block that worked was in the financial, made by the judge, in the financial firm that was a judge order that was not obeyed, and the firm was
was by the judge. You have like 10 seconds.
I just want to say that we have the other punishments that all the prosecutors are trying to get in the firm and not in the citizens. Just this.
Muito obrigado. Thank you so much. I'm going to jump right away. We have a few questions we received via Twitter here, and we welcome even more questions. We have a question from Aura Rus, who asks, besides the criteria in who has jurisdiction, is there any official international collaborative initiative on jurisdiction? And that's an interesting question. And I'm realizing we have a lot of Europeans, we have North Americans, we have Brazilians, obviously, speaking. But if there are common approaches, maybe in Africa or in Asia we haven't heard of, but somebody in the audience is aware of, it would be great to maybe hear of them as well. Should we take this question already? Bertrand, do you have no background? Okay.
Thank you. I think the quick answer to this is that it is a common problem that can only be solved by an appropriate discussion among the different stakeholders and among the different initiatives that are taking place. And so the strong message that we got and that we heard in the conference we organized in Paris 2 weeks ago was that no single actor or even group of actors can solve this alone. And the message of willingness, the message of urgency and the message of willingness to work together was very strong. And as Internet and Jurisdiction in the Policy Network, we are facilitating a discussion. It is up for the stakeholders and the actors to actually move forward, to connect with one another, to identify the elements that are common. But I would say that this topic has been ramping up in the last few years, is becoming extremely acute now, and has reached a sort of tipping point that makes me relatively optimistic on the likelihood of finding concrete elements moving forward out of a very large debate, going to very concrete solutions. And if you want more information about this, we have a booth, or go to internetjurisdiction.net and see the report of the conference online.
That's great. Maybe I can go to Alexander, because
If we talk about an international official way of addressing this, then you have what's happening in the framework of the Cybercrime Convention Committee. And it's actually not just a European exercise, because we have African countries there, we have Asia Pacific countries there, we have Latin American countries there, so it's not just a European exercise that is going on. And let's be very clear that these 5 solutions that I had put on my slide early on, some of them have already been accepted, but once all of them are accepted, that will shape how this is addressed in the currently 50 countries, but also in the other 20, 30 countries that are about to join. So this is not just now something academic in a way, it's going to shape the reality in those countries. And one point I want to underline regarding these discussions about other concepts, currently the solutions are focusing on subscriber information. We are not addressing the hot potato yet of content data that may have to be addressed through a protocol to the convention. But there is a lot of frustration about the concept of territoriality. Facebook has 140,000 or more servers in northern Sweden. If the Swedish authority couldn't even see the server park, one data, they have to go to Ireland for subscriber information and to the United States via MLA for content. This is just one example. I was recently in India, and the question now to Microsoft, I'm sorry to put a difficult case there. And in the conference center, just for the fun of it, I opened a new Outlook account. John Doe, whatever, at Outlook.com, and I could choose a jurisdiction. By default, it gave me India, because, so I took another one, Isle of Man. If I now commit a crime in India, and the Indian authorities want to investigate this, who do they go to? How do they even know that I had chosen Isle of Man as my jurisdiction? That's the sort of frustration we have. I would fully underline what Priscilla said from Brazil. Prosecutors and judges, they don't take this lightly. They don't just go for the fun of it after providers or whatever. There are serious cases of crime, situations of life and death, threat of terrorist attack happening or threatened to happen tomorrow. You need to act quickly on that.
Very good. Thank you. I have one more question here from Twitter, and then we'll ask if there's more questions in the panel, in the audience, hopefully it is. Should the IGF define each term of the concepts at play? And maybe so someone here is asking from Twitter if the IGF should identify each of the key concepts, which I guess is jurisdiction, for instance, is one of the key concepts we have been discussing. Any quick thoughts on that?
But the IGF is not allowed to make decisions.
Or is
we can discuss.
Suggested
no,
maybe.
the discussions are extremely important. Discussions like this, discussions yesterday in Bertrand's open forum, the initiatives are taking place a bit all over the world. Discussions of cases like the one in Canada right now, which is a civil case, by the way, and not a criminal law case. It's very important to discuss this, but we have to come to solutions. We cannot wait another. I said yesterday, 26 years ago, at the level of the Council of Europe, this was considered a highly urgent matter. We are still discussing, so it's not something we started yesterday.
All right, we'll take some questions. I see one question right here in front. One in the, two in the back there afterwards.
Hi, my name is Pedro. I'm from Brazil, from Institute for Research on Internet and Society. My question is concerning suppose we eventually states manage to make a framework of cooperation for sharing data and in cases of related to jurisdiction. But what would we do concerning possible how can I say it, digital safe havens, states that are not into those cooperation deals, and they just serve as havens for companies and etc. Or is that too early to think about it?
That's a good point. Then I think we have at least 2 questions right there.
Hello, my name is Jacqueline. I'm with Internet Lab in Brazil. I have a question for Bertrand. Shouldn't we, I'm sorry, yeah, another Brazilian. Shouldn't we be aiming at a multi-factor test to determine whether a country can directly request user data? The reason why I'm asking, I mean, by directly, I mean not having to go through an MLAT. The reason I'm asking is because it seems to me that Brazilian judges are unconsciously applying a multi-factor test. When I read decisions, I see judges arguing that, well, this company provides services in my country. I'm investigating a person that is in Brazil, and that most certainly is a Brazilian person. And also the victim of this crime that has been committed in Brazil is Brazilian. It seems to me that this would solve this solution that would acknowledge Brazilian jurisdiction in these cases would resolve 80% of the cases, right? And would deal with the frustration that the Brazilian prosecutors have voiced. Thank you.
Excellent. And very linked to the question about safe havens. I think there's a question just behind you, the gentleman just behind you. Hopefully not from Brazil. We'll see.
I'm neither Brazilian nor a lawyer, but my name is Byron Holland, and I'm a CCTLD operator. I run the country code top-level domain for Canada.ca. So my comments are really from an operator's perspective, though I've also just recently been chair of the CCNSO, which is the country code operator group in ICANN, with 160 CCTLDs.
And your question?
There. It's more a comment and suggestions. Would you like me to keep going, or do you want to answer the previous questions first?
No. Go ahead.
So as an operator, we face these challenges all the time. As an individual, I'm a strong proponent and believer of a free, open, globally interoperable internet, although I'm subject only to the laws of my own land as a Canadian corporation, which of course is the rub here and the reason for this discussion. Just picking up on some suggestions, we heard the Brazilian prosecutor we heard Microsoft talk about the situation in Brazil where they broke down the front door. Metaphorically, that happens to me as an operator frequently. Part of the solution is getting law enforcement to appreciate that a knock and an explanation is often very, very helpful. And I think we're starting to see that in some environments that discuss this subject, where law enforcement is coming and explaining and talking about their situation and propose solutions. That can be very, very helpful to the operators who, when the front door is broken down, tend to put their hand up, but explained rationally, as a community, are very open to helping law enforcement where appropriate. That said, I will only respond to the laws of my own land, so the multilats and those vehicles have to be in place in a meaningful way, because when a foreign prosecutor or law enforcement comes and tells me to do something, I don't and I won't, even if I know it's reasonable and just. And I think a very good example of that recently was the Avalanche takedown. So 800,000 domains were taken down. That was a cooperative endeavor with Interpol, etc. So there's lots of examples right now where it can work, but there's much hard work and small operational activities to engage in before we find this beautiful solution.
Great, thank you. I think we're going to take the questions now, and thank you for that good comment also about the need for a real dialogue, a practical dialogue between operators and law enforcement. I think if we can go to the 2 first questions, whether it would be an idea to have a multi-factor test to establish jurisdiction to solve, if that will solve many of the problems we're discussing, but also how we avoid the problem of sort of forum shopping, where maybe even criminals might pick a jurisdiction that is sort of not covered, where it's very difficult to have their data extracted. Maybe any quick comments? Yeah. Responses?
Thank you. On the question of kind of a multi-factor test, yes, there's a lot of debate going on about this in the US right now. Our Department of Justice has proposed a law that would enable service providers to respond directly to requests from foreign governments and not have to go through the MLAT process. So exactly kind of the scenario you were talking about. And there's a lot to be said about this bill, but a couple of key just sort of things that come up as we're thinking about this. One is sort of what are the criteria that a foreign government would have to meet in order to get this sort of special ability to serve a order directly on a company in the U.S. And those, what those standards are will be very, very important. One of the criticisms that my organization has had of the DOJ bill is that it presents the different factors like a demonstrated respect for rule of law, adherence to international human rights obligations, clear legal procedures, governing entities authorized to seek data, and some other things. It presents them as factors and not as requirements. And so we think that provides entirely too much leeway for a sort of potentially political determination of which country does the US want to make this kind of agreement with, and how can we sort of fudge the fact that they meet some of these factors, but also not others. But then I think another key question, sort of a meta level up, is who gets to decide which countries meet these standards? In the US, would it be only the Department of Justice or the Department of Justice working with the State Department, again, where there may really be a lot of influence of political considerations of international relations, or is this something that should be put before the legislature as well and have Congress, be able to evaluate how the standards are applied, how these agreements are assessed, and what decisions are arrived at?
Very good point. Do you want to follow up?
Yeah, a quick follow-up on the multi-factor test, because we had a session in Paris that was a short session on the future of territoriality as a criteria for jurisdiction. And this is a question that was raised very explicitly coming from the workshop sessions that people had earlier in that day. And there was a strong debate regarding whether a multi-factor test is appropriate or not. Some actors are legitimately considering that the current tests are too rigid and too simple, the Microsoft case being a perfect example of a very binary test on one criteria of territoriality. But at the same time, when the proposal of a multi-factor test, which, as Emma was saying, is part of the bill that is being explored at the moment in the US, was mentioned in that session, there were reactions considering that it is difficult to implement, that it is complex, and that in particular, for instance, including the nationality or the residence of the user is a very difficult criteria to evaluate. So there is a debate going on. I think on a personal basis, looking at the discussion, that the trend is towards a sort of multi-factor test, that it is more or less the practice that people are having, but there is still a debate at the moment in that regard. And the other element regarding the comment by Byron on having an explanation by the law enforcement, I think that the dialogue that has developed in the last few years on those issues has made people understand much better the position of the other side. But what he is talking about is also very operational in terms of what are the formats for requests, what are the informations that should be communicated to the operators, whatever the operators are, to justify the request for data, which touches, by the way, on a very important element of due process and trust building and so on, but also touches on issues of confidentiality, because we're talking about criminal investigations. How much data can be shared with the operators on criminal investigations? So those two elements, multi-factor test and procedural elements regarding the format for request, are some of the elements that are being discussed at the moment.
Any reactions maybe from Alex?
Thank you. I'm afraid that the territoriality principle, which this year in October celebrated its 90th anniversary since the Lotus case of 1926, and I think we may have to wait for many, many years before that is done away with. But what you see, was it already built in the Budapest Convention, and what we are now discussing with respect to subscriber information is not to focus on the location of data, because that's a very volatile concept, but to focus on the person in possession or control as the key factor. There are situations when it's perfectly all right, when it's acceptable, it seems like for subscriber information, where there are some doubts, in particular now from the Microsoft side regarding the issue of content and so forth. So for a long time you will have these dual principles that may govern the issue. But what I believe, no, I don't believe, what I could perhaps anticipate what may happen in the future, because you see it in other areas and in the European Union, that countries may require for companies to offer a service in their country to be legally represented in that country and to have somebody there to be ordered then to produce. That may be simply a law office, a law firm, that may be a branch, whatever. I think this is something it could develop, and you have it in the NIS directive in the EU, you have it in the data protection regulation and so forth, and we may perhaps see this also in the criminal law area.
Yeah, two finger to follow up exactly on what Alexander is saying. Actually, I fully agree with the trend that he is describing. One of the challenges is the scaling up of this solution, which brings a lot of questions regarding small companies and also small countries. Because if you push the reasoning too far, and you implement for any type of service the kind of rule that may be manageable for very large providers, it would mean that the proverbial 3 people in a garage who are actually developing a new application should designate a representative in every single of the 190 countries to handle those things. So, and actually I was discussing it this very morning with 2 people, and there is clearly a question regarding the scalability of this thing. It may have a threshold effect, it may have a replication effect, and I always like to quote in those regards in philosophy there's the Kantian imperative that you shouldn't do something if generalized it would look bad, and mandatory data localization and mandatory representation in a country is on the threshold of that kind of problem, because if you generalize it, it can be harmful for innovation and for smaller companies. But I agree with Alexander, there's a trend towards that. It's a portion of the solution, but we have to be careful in generalizing it.
I'm just going to give, this is very unfair, but a moderator, but I'm going to get a little bit of homework here for each of our panelists, but you only have like 2 minutes to do this homework. So I would ask you, we're going to discuss this next year at the IGF, I'm sure. At least Bertrand will be discussing it next year at the IGF. So what are we going to be focusing on? What are the elements, or what are the solutions, or the elements of towards solutions to be resolved in the next year to solve the challenges that we have been discussing regarding law enforcement access to cross-border data? Don't answer now. You have like one. We're going to take one more question, and then I'll ask each of you to like over 30 seconds to give your main points. So we have maybe one last question. Else, in the very, very back, yes.
Thank you. My name is Amber Sinha, and I'm from the Center for Internet Society, Bangalore, India. My question was with regard to MLAT reform. One of the main issues in terms of creating a multi-jurisdiction MLAT process has been with regard to which are the jurisdictions which qualify to be on it. On the one hand, there is an impetus that there should be human rights standards that all requesting jurisdictions should satisfy. On the other hand, if that standard is too high, then it ends up excluding most jurisdictions and rendering any treaty of that nature meaningless. So with that in view, I know CDT has also in the past come out with a proposal, and there have been, over the last year, there have been multiple proposals on ways to reform the MLAT process. My question was, is there any merit in looking at some kind of a staggered process which seeks to incentivize raising human rights standards in different jurisdictions so as to become a part of that network, where there is a minimum threshold that participating jurisdictions should meet, and beyond that minimum threshold, there are different steps, and as they rise within that framework, they could get more power or rights.
Very good question. Maybe CDT will take that.
Sure. Yeah. No, and that actually ties in very well with what I think we all need to be working on over the next year, which is how to answer this question. And I think the idea of a staggered implementation is a really interesting one that has a lot of promise to it, right? Because the question is, you know, in the U.S., if we come up with an agreement with a country that enables them to circumvent the MLAT process, that means the demand from that government does not have to be, you know, reviewed by a court in the U.S. And if it's an order for content, you know, does not have to meet a probable cause standard for turning over that material. From the kind of human rights perspective of trying to maximize privacy protections for as many people as possible, losing that probable cause standard really, I mean, that really does feel like a loss. That's not a going into a negotiation and saying, it's like, well, okay, maybe we'll do away with the very high standard of protection that currently exists, doesn't seem like a path forward to many advocates. But there have been a number of proposals that would put a somewhat lower standard, but with this idea that if you can get more governments to kind of reach a lower standard, that's doing a better job to sort of promote privacy in a greater number of places, and so isn't that a positive development? And I want to see if we can find out some way to move, lift all boats up toward a probable cause standard. Figure out how to ensure that when companies are handing over data, it really abides by the standard, which I think is pretty well reflected in the proportionality principle in the necessary and proportionate principles, which were the kind of coalition signed by hundreds of civil society organizations around the world, 13 principles for surveillance and due process. So I think looking to the necessary and proportionate principles is a great guide for how we proceed here.
Fantastic. Thank you so much. All right. What should we all be doing? What should academia, what should the internet and jurisdiction do? What should government be doing? What should company be doing? An international organization, what should they be doing until the next IGF discussion on the same theme next year? 20 seconds.
Well, fundamentally, there's a challenge of continuing to facilitate the interactions between the different stakeholders and the different initiatives that are working on this. And the fundamental expression that we put forward as Internet and Jurisdiction is to work collaboratively on due process standards across border. Due process is already difficult to do at a national level, but the big challenge is establishing due process standards across border, and that has a large number of underlying elements, but as a hook, that's the objective, developing a framework for transnational due process.
Lady, please.
Okay, in order to reduce the conflict among different jurisdictions, it is essential that the government, the society, and the law enforcement from all of the world make discussions and meetings to establish as more as possible common partners and procedures in authorities and judicial requests. And to protect users' rights, it's essential that the legislations about internet issues, especially cross-border data requests, be a result of a very open and previous discussion among the multi-stakeholders inside the country and between them. It's great. Like the prosecutors, federal prosecutors in Brazil thinks.
Thank you so much. Oh,
so what both of them said, plus at least within the U.S. and hopefully within other countries, that governments should actually begin to create active processes to re-look at how their national laws really interact with in the digital age across the board.
Well, I think I'm really glad to hear that Nady mentioned that it's important to have the participation of society in all this debate, and also I think we need to find ways in which we improve efficiency of the process to decrease the time that takes for judges and prosecutors to have the information they need, and transparency for sure. I think it's one of the main issues at stake.
In addition to the answer I already gave about how to strengthen privacy protections for everyone through whatever processes we're coming up with, on the transparency point, I'd also just note that government transparency is a crucial issue. This is not something that can be addressed solely by companies doing transparency reporting. That is very important, but the governments making the requests are the ones with the holistic view into their own activity, and so that's something that we'd really like to see continue to develop and improve in the next year.
So the next IGF is probably also in autumn. So before the next IGF, hopefully by June next year, we will have, I'm not speculating now, I'm saying we will have a review of the follow-up given by parties to the Budapest Convention on already existing recommendations to improve mutual legal assistance. That review is underway. By June next year, the report will be presented to the Cybercrime Committee. I hope that we will have consensus among the parties of the convention on Article 18.1b regarding subscriber information, so that we have a legal basis in the Budapest Convention for requests to service providers for subscriber information. I know, because we already agreed on that, we will have a range of practical measures implemented by then in cooperation with service providers to improve such cooperation, including regular meetings with the service providers, who, by the way, in that way, can also participate in the negotiation of the protocols to the Budapest Convention. And by June next year, I also hope we have a decision by the Cybercrime Convention Committee to start negotiation of a protocol to the Budapest Convention. So these are a few specific deliverables that we hopefully can report on as delivered at the next IGF.
That's terrific. You know, there's so much attention to this issue. There's so much agreement, it seems, among all our speakers here. So why don't we try and aim for that all together? At the next IGF, we'll be talking about how we all delivered on these solutions we've been discussing, rather than talking about how these should look like in the future. With no further ado, it's lunchtime. Please join me in a round of applause to all our speakers here. Thank you so much. Then you have to find something else.